Welcome to my channel, Legal Jargon. I've devoted my channel for explaining law-related concepts and other current affairs updates relevant for cracking judicial services exams and other competitive exams. Please like and subscribe my channel, and don't forget to hit on the notification bell for further updates. In this session, I would be covering the topic of injunctions, which is very important in terms of theory as well as practice. The definition of an injunction, according to the Halsbury law definition, is a juridical process whereby a party is ordered to refrain from doing or to do a particular act or thing. For example, the court can order an injunction whereby a party is refrained from throwing garbage into the neighborhood premises, causing nuisance to others. The Oxford Dictionary meaning of an injunction is a juridical warning or a judicial order restraining a person from an action or compelling a person to carry out a certain act. For example, the court can order an injunction where a person is supposed to pay maintenance to his wife, or a person has to destroy certain documents where he has wrongfully acquired copyright or trademark. Injunctions are of two types: temporary injunctions and permanent or perpetual injunctions. Temporary injunctions include ex-parte injunctions or ad-interim injunctions, whereas the permanent or perpetual injunctions include a mandatory injunction. A temporary injunction is granted when the defendant threatens to dispossess the plaintiff or cause injury to the plaintiff in relation to any property. So, for example, when the plaintiff is in lawful possession of the property and the defendant, without any claim of lawful title, tries to dispossess the plaintiff from the property. So, in that case, the plaintiff will be entitled to a temporary injunction against the defendant. The second condition is when the defendant is trying to create third-party rights as he is trying to dispose of the property. For example, the plaintiff has a brother who does not have lawful title over the property, and the plaintiff has lawful title over the property. But his brother tries to sell off the property under the guise of the actual owner to a third party. Then the plaintiff will be entitled to an injunction against his brother from doing so. A provisional remedy to preserve the subject matter in existing condition. So suppose, for example, your neighbor tries to break down your wall and encroach upon your land to build a structure. In that case, you will be entitled to a temporary injunction against your neighbor from doing so, to prevent dissolution of plaintiff's rights. Pertaining to injunctions, in the case of temporary injunctions, is given under Order 39, Rule 1 to 5, Section 37 of the Specific Relief Act, Section 94, Subclause C and Section 94, Subclause E of the Code of Civil Procedure, and Section 151 of the Code of Civil Procedure. In the case of permanent or perpetual injunctions, it is given under Section 38 to 42 of the Specific Relief Act. The remedy on refusal is given under Section 41 of the Specific Relief Act. And the execution of injunctions in general takes place under Order 21, Rule 32. Section 37 of the Specific Relief Act defines the temporary injunction to be granted for a specified period of time until further orders of the court are granted. A temporary injunction can be granted at any stage of the suit, subject to the regulation by the Code of Civil Procedure. Under Section 94, Subclause C of the Code of Civil Procedure, a temporary injunction is granted by the court to prevent ends of justice from being defeated. If there is disobedience with respect to the temporary injunction, then the court can put the person either in civil prison or order attachment of his property. Under Section 94, Subclause E, the court can pass any other interlocutory orders as it thinks fit to meet the ends of justice. Under Section 95 of the Code of Civil Procedure, when arrest, attachment or temporary injunction is granted based on insufficient grounds, then the court, not finding any reasonable or probable grounds for granting of the temporary injunction or making the arrest or attachment, will award reasonable compensation to the defendant upon an application made by the defendant, not exceeding Rs. 50,000. The reasonable compensation granted should not exceed the pecuniary limits of the court. Such an order passed by the court will further bar any suit for compensation with respect to arrest, attachment, and injunction. Order 39 Rule 1 states the circumstances under which a temporary injunction is to be granted or cases under which a temporary injunction is to be granted. When the property is in the danger of being wasted, damaged, alienated, or wrongfully sold in the execution of a decree. When the defendant tries to threaten or remove or dispose of his property to defraud his creditors. When the defendant threatens to dispossess the plaintiff, thereby causing injury to the plaintiff. Order 39 Rule 2. Injunction restraining repetition or continuance of breach. So in a suit restraining, it is granted in a suit restraining the defendant from committing a breach of contract or any other injury of any kind, whether or not compensation is claimed. The plaintiff can apply for a temporary injunction after the commencement of the suit, either before or after the judgment, restraining the defendant from committing any breach or injury or repeating the breach or injury arising from the contract. The court can grant an injunction for the duration by keeping aside certain security. Order 39 Rule 2A. The consequence of disobedience and breach. Upon consequence or disobedience of Rule 1 and Rule 2 or Rule 2 of Order 39, the court may order attachment of the property or detain the person in civil prison for a period of 3 months. No attachment can remain in force for more than 1 year. If the disobedience continues, then the property attached will be sold off out of the proceeds and the court will award compensation to the injured party. Rule 3 states that before granting of an injunction, the court has to issue a notice to the opposite party. The court has to direct a notice to the opposite party in all cases while granting of an injunction, except when the object of granting the injunction will be defeated by delay. Order 39 Rule 3 states that when there is a delay in the granting of the injunction and no notice can be served to the opposite party, the court will direct the applicant, after granting the order of injunction, to send by registered post to opposite party a copy of the affidavit in support of the application along with the plaint and documents relied upon by the applicant. The court has to file on the day the injunction is granted that an affidavit stating that the copies have been delivered. Order 39 Rule 3A states that the court has to dispose of the application for injunction within a time span of 30 days. When an injunction is granted without giving notice to the opposite party, then the court has to dispose of the application within 30 days from the date on which the injunction is granted. If the court is unable to do so, then it has to record its reasons for its inability. 4. An order for injunction may be discharged, varied, or set aside. When on an application made by the party dissatisfied by the order, or if the party has made a false or misleading statement in relation to a material particular and has not given notice to the opposite party, the court can vacate the injunction after recording reasons. An order for injunction has been passed after giving the party an opportunity to be heard, then the order will not be varied, set aside, or discharged, unless there are changes necessitated by the circumstances. Order 39 Rule 5, Injunction to corporation is binding on its members. So, an injunction made to the corporation is binding on all its members and officers whose personal action it restrains. Section 151 deals with the inherent powers of the court. In the case of Manohar Lal Chopra versus Rai Bahadur, the Apex Court has pronounced that the court has powers under Section 151 of the Code of Civil Procedure to issue an injunction in cases which do not fall under Order 39 Rule 1 and 2. However, such discretion has to be exercised judiciously and cautiously. Police protection can be granted along with the injunction under Section 151 as a form of inherent powers of the court, but this can be only granted with respect to final orders and not ad-interim injunctions. In the case of a temporary injunction, notice is granted to the opposite party under Order 39 Rule 3. An injunction can be granted without granting of a notice to the opposite party, and such an injunction is an ex-parte injunction. The court will exercise this option sparingly under exceptional circumstances. An ad interim injunction, however, is an ex parte order which is granted even without hearing the defendant. An example for granting of an ex parte injunction or an ad interim injunction can be in the case of intellectual property rights, where the plaintiff's company will suffer huge losses if an injunction is not granted seizing the infringing matter which the defendant possesses. So in such case, it is such an ad interim injunction or an ex parte injunction must be granted, and there is no requirement of a notice or hearing of the party. In Morgan Stanley versus Karthik Das, the Supreme Court has laid down the guidelines for granting of an ex parte interim injunction. They are as follows. The court has to examine whether there is an irreparable and extremely serious injury caused to the defendant. The court has to see when the notice of the act was complained, the particular time of making the notice, whether the plaintiff has acquiesced to the conduct of the respondent. In that case, an ex parte order cannot be passed, whether the applicant is acting in utmost good faith, and finally, whether the order is of temporary nature. Four test is followed for granting of a temporary injunction. The first being that there must be a prima facie case which must be established. The second is that injury or irreparable loss must be caused to the plaintiff. And the third is that the balance of convenience must lie in favor of the plaintiff. The first test for granting of a temporary injunction is that there must be a prima facie case, a strong case for trial on the face of it that needs investigation and a decision on merits. The probability of the applicant coming to court and seeking a relief must be high. That the applicant must be in a requirement of an immediate relief. There must be a prima facie case and an infraction of such a right. The court has to cannot examine the merits of the case closely. The court has to be guided by the plaint affidavits and other material. The applicant who is approaching the court for a temporary injunction has to do so with clean hands and must not suppress material. The second test for granting of a temporary injunction is that there must be irreparable injury caused to the applicant if the injunction is not granted to him and there is no other remedy that is available that can protect him from the consequences of the apprehended injury. The injury must be such of a material nature that cannot be adequately compensated by way of damages, and that there should be no pecuniary standards for measuring the damages. Granting of an injunction is an equitable relief and can be only granted when judicial intervention becomes absolutely necessary. The third test for granting of a temporary injunction is balance of convenience, which must be in favor of the applicant. The comparative mischief, inconvenience, and hardship will be greater cost to the applicant by refusing it than cost to the opposite party by granting it. A perpetual injunction is granted at the time of passing of the judgment and it ultimately disposes of the injunction suit. It continues as long as the petitioner holds the basic right or status in relation to the property or status with respect to which the injunction is granted. The elements for granting a perpetual injunction are that there must be a breach of an obligation or infringement of a legal right. For example, a tenant who is in lawful possession of the property cannot be evicted by the owner without following the due course of law. If the owner evicts the tenant without following the due course of law, he can approach the court for granting of a perpetual injunction as his legal right has been infringed. The second element is the person must prove lawful possession. The person must show that he was in lawful possession of the property, and a person without rightful title is trying to dispossess him. A perpetual injunction can be also granted for protection of juridical possession. Now, what is juridical possession? Juridical possession is contrary to lawful possession. For example, a tenant, continues to stay in the property without the consent of the owner. In this case, it is not lawful possession, but still, a perpetual injunction can be granted to prevent any high-handed acts of forcible dispossession. So here, the tenant who is staying on the property without the consent of the owner can approach the court for a permanent injunction preventing forcible disposition. Symbolic delivery is sufficient to sustain an action for injunction. Symbolic delivery means actual delivery of the possession. In case of symbolic delivery, the court has to examine whether the person was in possession of the property at the date of filing the suit. So, the four elements have been covered. These four elements are essential and have to be kept in mind before granting a perpetual injunction. Examples of perpetual injunctions are as follows. A suit for injunction by a person without a title. When a person is in possession of a property without a title, or a tenant is in possession of property without a title, he can obtain an injunction against the rightful owner for forcible dispossession. Second is an injunction against a lessee. A lessee or a tenant who is in possession of the property can be prevented from making any material or structural changes to the property without the consent of the lessor through an injunction. It is the duty of the tenant to hand over the property in good condition subject to reasonable wear and tear to the owner. If he does not do so and he makes some structural changes in the property, then the owner has a right to obtain an injunction. The third example is injunction against a lessor. This is similar to the first example where the tenant without rightful title can obtain an injunction against the rightful owner for forcible dispossession. The fourth example is injunction against co-owners. When there are co-owners of joint property, then if one of the co-owner uses the joint property for his own benefit without the consent of the other co-owner, then an injunction can be obtained against such co-owner. For example, there is a joint well and one of the co-owners draws water from the well to irrigate other lands which are not the joint lands of the co-owners. In this case, the other co-owner can obtain an injunction against the co-owner who is drawing water from the well. The fourth example is injunctions in the case of Champertus agreements. Champertus agreements are not per se illegal by law, and they become illegal only when they are against public policy. This has been declared by several judgments given by courts. A Champertus agreement is an agreement where a third party is funding the litigation of the litigant in return of consideration as a result of successful litigation. If the litigation results in the court granting proceeds to the suit as a result of the suit, then in that case a share of the proceeds will be shared by the third party. Injunction in the case of nuisance. So an injunction can be granted in the case of nuisance where suppose a machine or any other instrument has been is being installed in the neighborhood by one of the parties. So in that case, the neighbors are finding it difficult to carry out their functions because of the loud sounds being caused by these machines. Then in that case, an injunction can be obtained against such party. Injunction in the case of easementary rights. When there is a prescriptive easementary right to light or air, and this easementary right is being infringed and causing infringement in the comfortable occupation of the person holding the easementary right, in that case he can obtain an injunction against the party who is infringing the easementary right. Injunction against a trustee. An injunction can be obtained against a trustee where there is some changes, material alterations being made to the trust property. Preventing such changes to be made to the trust property, an injunction can be obtained. Injunction to prevent waste. When waste is being generated, causing damage to land or damage to the land of a person, of a person, or if there is, for example, a Hindu woman who's purchased shares and is using the investment in a wrong way, causing capital depreciation of the property, then in that case, if waste is being generated, an injunction can be obtained against the waste from being generated. Injunction to prevent trespass. If there is a trespass, a threatened trespass to the rightful possession of a person, in that case an injunction can be obtained. An injunction granted during insolvency. Insolvency courts can grant injunctions based on the circumstance of the case. If a particular case requires an injunction to be granted, then insolvency proceedings can be initiated in insolvency courts, and the insolvency court will grant an injunction. Injunction in the case of companies. Injunctions can be granted in the case of companies in the courts which hold jurisdiction. For example, if there is the proper voting has not taken place, or the director the person has not obtained the requisite shares to be a director, or an injunction against winding up of the company, all this can be obtained provided the court has to have the jurisdiction. Injunction against the government. An injunction can be obtained against the government or any public officer acting in his official capacity without giving notice, even without giving notice to the other party, but a right of hearing should be given to the public officer before injunction is granted. Injunction against a person lawfully entering into the possession based on agreement of sale. When there is an agreement of sale and it has not been specifically performed, an injunction can be granted as a form of relief for specific performance of the agreement of sale. The last example is a suit for declaration and injunction. A suit for declaration and injunction can be filed at the same time. For example, if a person's title is in question and he is also being forcibly dispossessed from the property in which he is in possession of, in that case he can file a suit in the court for declaration of title as well as injunction against his forceful dispossession. It's given under section 37 subclause 2 of the specific relief, the definition, and it is basically granted at a time when at the final stage of the hearing of the suit where the merits have already been decided of the suit. The defendant here is perpetually or permanently enjoined from the assertion of the right or commission of the act. Section 38 of the Specific Relief Act deals with the situations or circumstances where a perpetual injunction is granted. The first is when the defendant invades or threatens to invade the defendant's property or the plaintiff's property, and the defendant is a trustee of the property of the plaintiff, where there exists no standard for ascertaining actual damage caused, and compensation in money is not an adequate relief, and also in order to prevent multiplicity of proceedings. Section 39 of the Specific Relief Act deals with mandatory injunctions, which are also a form of perpetual injunctions. They are granted in order to compel performance of certain acts which the court is capable of enforcing. It is in the discretion of the court to grant the injunction to prevent the breach complained of, and in order to compel the performance of requisite acts. For example, a mandatory injunction can be where a breach of contract has taken place and a party had to deliver certain goods to the other party but hasn't done so. In that case, a mandatory injunction will be granted by the court compelling the specific performance of a party to deliver the necessary goods. This is to enforce an obligation. The other can be to restore a certain thing. For example, a mandatory injunction can be granted against a person who has posted something confidential or illegal online. In order to remove such illegal or confidential information from the net, a mandatory injunction can be granted against the person who has posted it. Section 40 of the Specific Relief Act deals with damages which can be claimed in addition or in substitution of the injunction. So, when a perpetual or a mandatory injunction is being already claimed, damages can be claimed in addition to or in substitution of such an injunction. But no damages can be claimed when it is not been claimed in the plaint. So initially it has to be claimed in the plaint for claiming such a relief. and the court can allow the plaintiff to amend the plaint at any stage for including a claim for damages. A dismissal of suit to prevent the breach of an obligation will also, in favor of the plaintiff, will further bar a right to sue for damages for such breach. If a suit has been dismissed on the grounds of breach of an obligation, then a person cannot raise another claim for damages again. An injunction is refused under Section 41 of the Specific Relief Act in the following circumstances. When an injunction is filed for restraining a person from prosecuting a judicial proceeding pending at the institution of the suit where injunction is granted. So a person cannot be disallowed from prosecuting a judicial proceeding at the time of pending of the institution of the suit for an injunction. The second case is when an injunction is granted to restrain a person from instituting or prosecuting a proceeding in a court having superior jurisdiction or having a higher jurisdiction. So in this case, a person can institute and prosecute a proceeding in a court of superior jurisdiction, and no injunction can be granted restraining a person from doing so. Refusal of an injunction can take place when it is to restrain a person from applying to a judicial body or prosecuting or instituting a proceeding in a criminal matter, or preventing of breach of contract whose performance cannot be specifically enforced. It will be refused also when it is to prevent an act of nuisance which is not reasonably clear. Only when the act of nuisance is clear, the injunction can be issued. If there is a continuing breach of which the plaintiff has acquiesced, in that case, an injunction cannot be granted. When there is an equally efficacious remedy that can be obtained by other means, then an injunction will be refused. Injunction will be refused when it is evident from the conduct of the plaintiff or the agents that they do not want the assistance of the court, and it will also be refused when the plaintiff has no personal interest in the matter. Execution of an injunction takes place under Order 21, Rule 32, Subclause 1 of the Code of Civil Procedure. If there is a disobedience of the decree passed under Order 21, Rule 32, Subclause 1, the court can order attachment of the property or detention in civil prison or award both remedies. The differences between a temporary injunction and perpetual injunction are that in the case of a temporary injunction, it is granted for a specified period of time or a temporary period of time and can be adjudged at any point when the proceedings are taking place of the suit. In the case of a perpetual injunction, it can be granted only through a decree and can be passed by the court only upon the examination and facts and merits of the case. A temporary injunction is governed under Section 37 of the Specific Relief Act. Section 39, Rule 1 to 5 deal with temporary injunctions. Under the CPC, it is dealt under Section 94, Subclause C and Subclause E, Section 95 and Section 151. It is in the case of a perpetual injunction, it is governed under Section 38 to 41 of the Specific Relief Act. A temporary injunction is non-conclusive and lasts for a short period of time, whereas a perpetual injunction is final, conclusive, and lasts permanently. A temporary injunction can be revoked by the court. However, a perpetual injunction is non-revocable by the court, but it can be appealed. An appeal can be made against a perpetual injunction. A temporary injunction is simply an order passed by the court, whereas a perpetual injunction is an official order passed by the court of law.